I've been asked to act as a discussant. I think both experts addressed very detailed and made a very detailed and very extensive analysis of both compacts and their relevance today, and the challenges that are that we are facing now when looking at what is next to come. I wanted to perhaps add a few of my personal views on both of these important instruments. I think, as our colleagues have mentioned earlier, probably the most positive aspect of all of this process has been that states have stopped ignoring the unavoidability of migration and have decided to address it up front, trying to find solutions rather than simply pushing problems forward and ignoring them. And that in and of itself is a very important accomplishment, I think, in particular, as we were saying earlier, with the growing threats related to climate change and current conflicts. Another very important accomplishment in both of these processes was that they involved a very broad range of actors, state and non-state actors, with their own perspectives and expertise. And this allows, again, to have a more realistic approach to the issue of migration and the rights of refugees, and to address it in a holistic way, as was mentioned earlier. I think another extremely important gain from both of these processes is that while it is not a binding instrument, it is very detailed in terms of measures that need to be adopted so that the objectives, the different objectives are met. And this is uncommon for international instruments, even for non-binding international instruments, because, of course, as was said earlier, they need to be negotiated, and often we try to adopt short and vague documents rather than adopt very precise, detailed instruments, because they're more difficult to negotiate. So I think these are, some of the very positive aspects of these processes. Of course, there are criticisms, as was said earlier, and from a jurist's point of view, of course, the first being that it's not a treaty, and it's not binding, and it provides general policy orientations. But of course, while they both address very broad aspects of migrations and refugee-related matters, in terms of policies, in terms of economics and so forth. An important part of the issues addressed in both of these instruments relate to human rights. And human rights are governed by different instruments already. And I think it's important that all the states that are serious about protecting the rights of migrants and refugees ratify and recognize their international human rights law obligations, including under the Convention on the Human Rights of Migrants and their Families. That has not been ratified by many states, unfortunately, in the Northern Hemisphere. It's not been ratified by Canada as one of the few instruments that, like human rights instruments, that Canada has not ratified. Another instrument being the Convention on Enforced Disappearances, which I will address in a few seconds. Other critics that can be formulated, of course, is focusing more on the Migration Compact, is the fact that some macro problems are not addressed. Thinking in particular of the fact that underground markets of the Northern Hemisphere, which are often employing a migrant labor force in very unacceptable conditions, are demanding greater quantities of workers, and this is an important problem that is broad and needs to be addressed by very concrete policies, as well as economic sectors that, notwithstanding free trade, have not been delocalized. For example, in the agricultural sector, where again, in certain environments, there are serious problems for the human rights of migrants who work in these areas. I wanted to perhaps, because of my former actions as a member of the UN Working Group on Enforced or Involuntary Disappearances, address the issue of disappearances in the context of migration and how it relates to the compacts. As you probably know, in 2017, the working group adopted an important report on enforced disappearances in the context of migrations, which was submitted to the Human Rights Council and has been welcomed as a very timely report. It addresses a series of issues, including migrations that are caused by enforced disappearances, but mostly it addresses disappearances in the context of migration, disappearances of migrants due to political reasons. So basically the repression against refugees abroad, something that unfortunately is increasing. The working group has just adopted a very important report on disappearances and transnational transfers, which in many cases concerns refugees and how they are captured inter countries by their countries of origin. But the migration report also addressed disappearances in the context of capture and detention of migrants, and in the context of deportation proceedings, and highlights patterns that are occurring today. And the report formulated a series of very important recommendations, including, of course, many of which are relevant for the compact, and in certain circumstances, in certain areas, overlaps what the Compact on Migration has set as objectives. Of course, as you can imagine, the coordination between different multilateral initiatives is always difficult. Our report was, of course, submitted to our colleagues working on the Global Compact, in particular to Louise Arbour and her secretariat. But and we have also participated in some of the forums which were prior to the adoption of the Compact, in particular in Dhaka, Bangladesh in 2016. We also had the chance to present our main conclusions at the Standing Committee on Citizenship and Migration in 2018 to address these important issues. And some of the main, but basically it's of course very difficult to ensure coordination between both initiatives, as they relate to primarily to the different objectives. But some of the elements that are common to both types of recommendations, and I wanted to highlight, deals with, of course, the importance to have serious scientific data on migration, and of course how it relates to disappearances. Many of the recommendations also cover prevention measures, in particular in terms of consular assistance, communication of families with communication of the migrants during the migratory routes with their families and their loved ones, access to justice, in particular in detention and deportation procedures, of course. Of course, we have reiterated the fact that detention of migrants should be in an absolute last resort measure. That migrating, whether in a documented or undocumented way, is not a crime and should not be sanctioned with criminal sanctions. And of course, considering that many migrants have disappeared in these processes is very important to highlight. We've also formulated important measures to prevent disappearances during the deportation procedures, in particular with the phenomenon of pushbacks. One of the key elements that we've recommended is to make sure that when migrants are returned, they are able to exercise all their human rights, and that these are documented processes to avoid human rights violations. And these are elements that we see again in the objectives for safe, orderly, and regular migration in the compact. So I think it's important that that when we look at these phenomena, we draw parallels between these initiatives so that they are not going in different ways. Now, I wanted to finish my comments by addressing some of these issues that have been addressed by my two colleagues earlier. But I think one of the challenge will be what comes next, will be the monitoring. Of course, again, it's not a treaty, so it doesn't have the same monitoring instruments that we sometimes find with treaties. But there are monitoring processes that are provided for. I think it will be a challenge to make sure that these are effective, some of which are to be operative as of next year. It will be a challenge to ensure broad participation in these processes of monitoring, including participation of migrants themselves. I think one of the main challenges, again, from a jurist point of view, will be to see how some of the objectives which relate to human rights obligation, and in particular, which relate to economic, social, and cultural human rights, will be assessed. Some have suggested to use indicators, and again, indicators are sometimes difficult to work with and are also the object of criticism, in part because indicators are often the chasse gardée of experts rather than invite for a participatory process where individuals and groups which have less access to certain policy arenas are unable to participate. In any case, I think the monitoring of such an ambitious program is a challenge, and will need to be looked at very closely. The important point is that civil society, states, and other stakeholders maintain the pressure so that these issues are addressed permanently, not in times of crisis. these are issues that are here to stay, and we need to crystallize certain of these principles to make sure that lives are saved and that we live better in better environments together.